All right, so I'm here with Dr Ben Schrader. My name's Bridgette Toy-Cronin. I'm the Director of the Legal Issues Centre at the University of Otago. And as part of our Civil Justice series, we are here with Dr Ben Schrader, who's an independent Wellington historian who's joining us in Otago today. He specialises in urban history and historic preservation. He was a senior researcher at the New Zealand Historical Atlas and has written extensively for Te Ara, the online encyclopedia of New Zealand. Ben wrote We Call It Home, A History of State Housing in New Zealand, which was published in 2005, and also The Big Smoke, New Zealand Cities 1840 to 1920, published in 2016 by Bridget Williams Books. The Big Smoke won the 2017 W.H. Oliver Prize, and Ben's also the recipient of the 2017 CLNZ Writers Award, which is one of the largest grants awarded for non-fiction writing in New Zealand, and that's for his project to research historic preservation. He's also a member of the New Zealand Centre for Sustainable Cities. Now, Ben is joining us here as our visiting fellow with the Legal Issues Centre, and he, along with myself, are team members on a Royal Society funded project on eviction, which is a multidisciplinary team, including Ben as a historian, myself as a socio-legal scholar, and it's being led by the University of Otago's Department of Public Health in Wellington. So welcome to Dunedin, Ben.
Kia ora, Bridget. It's nice to be here.
Yeah, it's great to have you and to be able to have a conversation about the research that we've started this year. Definitely an ongoing project, and we're very much at the beginning, but we thought it would be great as part of our explorations in civil justice to talk about what you've been finding in your time in the archives, specifically about the history of tribunals in New Zealand, and we now have the tenancy tribunal, which we're looking at as part of this project. But we thought it would be useful to go back and look at what came before that. So what did come before the tenancy tribunal? Can you tell us?
Yeah, thanks, Bridget. Well, as you were saying, I've just sort of started this project in the last few months, and as a team member, I'm trying to look at, the lived experiences of people in eviction in a historical perspective, how they experienced eviction, but also looking at some of the legislative framework, and how it was framed and what the legal avenues were in terms of people wanting to appeal decisions or think something is unfair and those sorts of processes, the civil justice aspect of it, as you're saying. So I am at the beginning, and I am still finding out information, but I think I can say that I'm making some progress. And what I've found out so far in terms of the antecedents to the tenancy tribunal is that discussion about such an agency or forum really began in 1916. At that time, there was talk about people were being evicted from their homes, rents were going up during war, and there was quite a lot of concern, particularly for soldiers and soldiers' wives and families, about the fact that, their husbands were away fighting for the war, but here we have landlords that were staying at home were increasing rents, and that was seen as being really unfair.
So back in 1916, so we're in the middle of World War II.
One,
sorry. Yep. World War One.
Yep.
And that would be when we had the Magistrates Court in New Zealand.
Right.
So that's our first it's our forerunner to what we now have as the District Court.
That's right.
So was that the jurisdiction?
That was the jurisdiction ever since colonial times. So if there was some dispute between tenant and landlord, they inevitably went to the Magistrates Court. So whether it was over issues about eviction or damage to property and those sorts of things, they were dealt with there.
Right.
Part of the problem then is, as in more recent times, was the expense of that, and so a lot of occasions tenants didn't have the money to appeal evictions and those sorts of things. So there was a lot of talk about what was needed in terms of improving the lot of tenants was something like a fair rents tribunal, and that went back to Scotland and Ireland, where they had land courts where particularly rural tenant farmers, if the rent was increased by the landlord, they could go to the land courts and then the land court would fix a fair rent. And in 1916, in New South Wales, they're looking across there and they established a fair rents court there. And so people are saying, well, why can't this happen in New Zealand? But in fact, the government decided it wasn't appropriate, but what they did instead was bring in what they call rent restrictions in 1916. So
that was a piece of legislation as opposed to a new forum.
That's right. Oh. And so they said that if a tenant was seen as getting an unfair rent, they could go to a magistrate's court, and then they could fix a tenant and fix the rent. I'm sorry, fix the tenant and the landlord. Yeah. And that was based on a fair rent being the rental that was paid at the beginning of World War One, so in 1914, or as a proportion of the improved capital value of the house. So if the landlord had gone and done renovations and that sort of thing, the magistrate could take that into account. And so
this is to protect the position of soldiers who are, or soldiers' families who are away.
That's right, because very much that thing that, people are fighting to save, empire.
And rip up the home in half
exactly.
While they're away.
That's exactly right. And another measure that was brought in 1918 was that there's concern about evictions, and soldiers' wives or soldiers' families couldn't be evicted under a new amendment to the war restrictions, and unless there was for non-payment of rent or damage to property and those sorts of things. And that basic legal framework stayed pretty much in place through the 1920s.
Right, okay. So, I mean, the tenancy tribunal itself didn't come into, 86?
Yeah.
So was there something else that, 1916, a while ago now.
Yeah, what basically happened is that the same system continued through the 20th century, and so in 1936 the Labour government brought in a Fair Rents Act, again, where tenants could go to a magistrate and have a rent fixed, and that was based on, in terms of the beginning of the Labour government in 1936. Again, there was provisions in terms of if there's improved value and that sort of thing.
And have you found anything which is sort of talking about continued complaints about the lack of access to the magistrates' court to enforce that? Or, I know you're only at the beginning of research, but, this is a theme that, of course, the Legal Issues Centre is still dealing with in our modern system.
That's
so it'd
right.
just be interesting to know if there's echoing down.
I haven't explored that to any extent yet. There was certainly an impression coming through the newspapers that not everybody could use it.
Yeah. So you've got a legislative amendment that's designed to help tenants, but whether you can then put it
whether
into
you've
action.
got the means to actually put was quite different. And what tended to happen over the course of the from the 1940s and 1950s is that you get the Tenancy Act came in 1948 and then another in 1955, and that kind of over the years weakened the fair rents legislation.
Right. So starting to move back to
that. So there was a sense that by fixing rents, you're actually discouraging landlordism. It wasn't a case landlords would exit the rental market, and then that would in fact increase rents because there'd be less rental properties available.
And that's so interesting with the discourse we've seen this year in the papers about the,
very much the case. And then just taking it up to the 1970s. At that time, it was quite a high period, early 1970s, high period of inflation, and so the national government at that time brought in measures. They called them price stabilisation measures, but they excluded rents. And again, they excluded, so it affected wages, prices, in terms of groceries and those things, but excluded rents. Again, on the premise that if rents didn't increase, landlords would exit the rental market. Now, the Labour government said that, not Labour government, the Labour opposition said that, that was unfair, that landlords were increasing rents in cities like Auckland and Wellington and were even rack renting, and that was encouraging overcrowding. And so...
So what's rack renting?
Oh, well, just exorbitant rents.
Oh, okay, like a rack rate in a hotel.
Yeah, that's right. And so there's lots of discussion in Parliament, and in fact... the Labour opposition put in a private members bill that was drawn up, and they said that they wanted to set up rent appeal boards, which would set an equitable rent. The national government threw that out, but in fact Labour won the election at the end of 1972, and one of the first things they did was bring in again rent restriction measures and setting up the Rent Appeal Authority, and that oversaw rent appeal boards that were set up in each of the 4 main centres.
Oh, okay. So you've got 4 rent appeal boards which are now taking some of that jurisdiction from the magistrates' court, or at least and some new legislation as well.
Yeah. So the idea was that a tenant who thought that he or she had an unfair rent increase could go to the Rent Appeal Authority or particular board, and the Rent Appeal Board would then take things like valuation around the place and set what they would call an equitable rent, and that was basically defined roughly as a rent that was reasonable for a landlord to charge and reasonable for a tenant to pay.
So that would have fitted with that period where there were controls on other prices, or at least inflationary. So this is just kind of a new mechanism to extend that kind of control out.
That's right.
Because that's quite different from what we've got today, right?
Yes,
I mean, there's not really even any discussion about, well, maybe there's a bit, but not much in the main media about actually putting a ceiling on rents.
No, that's right. Well, it went back to back to World War One with the rent restriction legislation and the Fair Rents Act. And I mean, it's very much that time in the mid-20th century where government would intervene in the economy. And then we moved away from that idea in the 1980s. Yeah.
But so, and by this time, I think the District Courts Act is 1947, that's memory. I'm not sure if that's right or not. But so the District Court would have been in action by now, or the courts.
Yes, that's right.
And then you've got this new body popping up off the side.
Yeah.
And maybe some other tribunals starting to come up too.
We'll need to look at that actually, because, here's a semi-judicial authority, which has those powers to set equitable rents, and so it would be interesting.
It would be, because I mean, there's in New Zealand today, there's more than 100 tribunals looking at different things. So we've got, at some point, this proliferation of tribunals happened. Right, And I mean, it's also quite interesting that you referred to the other jurisdictions like Australia having a rent court. Yes. And we had the Māori land court. True. So we did have this other kind of court system, but for whatever reason, we've stuck for quite a long time with the general jurisdiction of the district courts.
That's really interesting.
We've got, so it'd be quite, I'd be quite interested
to follow that up.
Talk about that one more. Okay, so in the Rent Appeals Authority and the rent boards, I mean, have you had a chance to look into cases there?
Well, I mean, one of the things that in 1973, there were sort of people saying, well, there's really slow uptake about, people applying. And at one point in February, apparently there'd only been 20 determinations made, and they're expecting a flood because of the sense that there was a housing crisis going on. And it was quite interesting because the unionist Sonia Davies, she sort of wrote to the government at the time and saying, well, nobody's applying because nobody knows about it, and you need to give more publicity, and
sell your tribunal.
Yeah, that's right. And then Jim Delahunty from New Zealand Race Relations Council said, well, a lot of immigrants coming in from the Pacific Islands are affected, but they don't know about it either. Would you consider printing a leaflet about the rent appeal boards in their own languages so they could understand it? And the government was really reluctant, and Hugh Watt, who was the Department of Labour Minister, said, well, no, we're reluctant to do that because we want Pacific migrants to integrate or assimilate into New Zealand society, and they needed to learn about New Zealand, and this
so
would...
just first you have to learn English, and then you can learn about this.
That's exactly right. And, it didn't take into account the fact that, not all immigrants had access to English language classes, not all were up to speed in terms of life in New Zealand and what it meant to doing that.
All the barriers that might be there to actually get to those points,
that's
including
exactly
things like your rent.
And I mean, a really interesting case study I came across concerned a Polynesian family in Newtown in Wellington, and they'd moved into this basically dive, and there was no guttering around the roof, and so when it rained, the whole back of the house flooded, and talk about swamp houses,
which is today's news.
Yeah. And so the Wellington Tenants Association found about it, and they said, well, you should go to the the landlord had put up their rent from $24 to $28, and which was a high rent in those days, if not now. And so the Wellington Tenants Authority said, look, you needed to go to the rent appeal board, and so they helped the family take their appeal to the board, and the board found in their favour and said that the rent was unjustified. But what happened is that they then sent their determination in a letter which was all in legalese, and the tenant couldn't understand what it was all about and continued paying the same rent.
Oh wow! Yeah.
And so
very interesting.
And so there was a whole lot of discussion about, from the Wellington Tenants Association, saying, well, you've got to use plain English, or you need to, have an advocate that then will go to the house and say, this is what's been decided. And so
the plain English movement and law hadn't started.
No, that's right.
So it's so interesting to hear about that kind of scenario back then, and also the unwillingness of the government to translate, which is really quite different from today.
That's
and
right.
The idea of what the media have coined the swamp house is something which has got those echoes through to today.
It sure has, So, and then there was also sort of growing criticism sort of by the mid-1970s that the rent appeal boards are out of touch with the communities.
Common criticism of judicial bodies,
And so, for example, the Auckland Rent Appeal Board said, well, we're not getting many cases from Maori and Pacific Islanders, and that's because they're satisfactorily housed. Mild complaints were coming from Pākehā, and this led to a sense of incredulity among the Pacific Islanders Welfare Association, and a guy who was the chair of them, called Stephen Numata, came back and said, this is absolute rot. The reasons why Pacific and Maori aren't applying to the rent appeal boards is that they fear eviction. And that if they, go through the process, the landlord finds out, then inevitably they'll be evicted. And so and then there's also the cases that the Auckland Tenants Association pointed out, well, the whole process is overly bureaucratic, and it can be really intimidating for those that that aren't familiar with the types of system. And they basically said, well, it's really only set up for sophisticated people, and they're the only ones that can use it, can get through the legalese and the bureaucratic process. And so there is real challenging of the idea that Pacific and Maori people were housed well.
Oh, and that story you can sort of see where some of the reasoning for the tenancy tribunal might come from, right? Because then that's specifically been set up to try and be very informal and accessible.
That's right.
And that I understand is going to be the next stage of your research.
Yes, that's exactly right.
Yes. So it'll be really interesting to see what that comes up with as well. Because part of this project that we're doing is about looking at how that now operates. And I just think it's so interesting to see the context from where those actual bodies came from, and the kind of changes over time and the promise. So thank you so much, Ben, for joining us here today in Dunedin, and we are very excited to keep on working on this project.
Well, it's lovely, and it's lovely working with you and the others in the team. It's fantastic. Thank you.
Okay, thanks very much.